Please state your name. I'm sure you have your witness form, and proceed when you're ready.
Yes, and I submitted my witness form to the basket a minute ago. My name is Sean Smith. I am a Jackson County legislator. I was first elected to office and began serving on January 1st, 2023. A fortuitous time for those who followed along with our assessment issues, to say the least. In my time in office, I've kind of become the de facto champion for taxpayers, I'll say. Not because I chose to, just because somebody needed to. My background with finance, accounting, large systems, kind of it fit in with my situation, my professional background. What I want to bring to the committee's attention, of course, is that it is the specific portion of the Constitution that allows Jackson County to have an elected assessor or an appointed assessor. That portion of the Missouri Constitution says that between 6 and 7 counties with a population between 6 and 700,000 can have an appointed assessor. That means that another county someday could grow into that population band and potentially be in this same situation. For those of you who might be in smaller counties, envision the day where your county grows to that level, and then let me describe for you, as well as another witness that I brought with me today, who's our former assessor, what it would mean to be an appointed assessor. So to do this, I think the best way to do it is to point out some very tragic situations that this has created in our county, not just because the assessor's not elected, but I'll circle back to why that's so important in a moment. What we have, and many of you might not be intimately familiar with the timelines when an assessment occurs, but essentially January 1st of 2023, the assessor theoretically valued every property in the county, then notified taxpayers of that value in May. They began to have the opportunity to appeal that value if they thought that it was incorrect. The assessor in our case has significant authority to interact with the Board of Equalization. That's the jury and judge that determines the value of your property. I have right now constituents in 2025 who appealed their assessment in June of 2023, whose cases still haven't been heard. What that means is that their mortgage payments in some cases doubled. So imagine you have a constituent who, in one case, had a $600 mortgage. This is not somebody that had significant savings, but they had some. And over the last 18 months, it's been depleted while they're denied due process. Why are they denied that due process? Because of the volume of issues, but also because of a lack of willingness to intervene and even resist the lawful order of the State Tax Commission that said that those assessments weren't done properly. That's the amount of authority that has been vested in this person. And it is effectively denying, if we all know the phrase life, liberty, and most people think the pursuit of happiness, that's in the Declaration of Independence. What's actually in the Constitution is life, liberty, and property, that you shall not be deprived of those without due process. Well, I'm sorry, but if you have a mortgage, your mortgage company, if you're not able to pay an inflated mortgage, isn't going to wait for 2 years. We have created a situation in Jackson County specifically that is tragic, and what it is doing is eroding overall trust in the government because people don't have an elected assessor. They don't have a say in the one person who has all this authority. I don't know of another place where such authority resides, where some individual can callously and coldly decide that your value of your property's $900,000, when just last year she certified that it was worth $200,000. And the opposite can be the case. The abuses that I've seen where a property that's $1 million lakefront property in the Lakewood community of Jackson County is sitting there on the tax rolls in 2022, and either through mistake or by intention, now it's valued at $200,000. With the Hancock Amendment, what that means is that as one taxpayer is alleviated from some of their tax burden, other taxpayers incur it. These are all provisions in the Missouri Constitution. That's why this needs to be corrected in the Missouri Constitution with this HJR. Whether or not this is appropriate for St. Louis City, not here to say one way or the other. Last thing that I'll say, I wrote it down. The idea that this erodes overall trust in government is just out there and pervasive. People in our community are actively opposing virtually everything, to the point where we've now had a process server who is showing up to let somebody know they need to leave their house, shot and killed along with an Independence police officer. That was a direct attribution of a property tax issue. You can't fix all these issues. What you can fix is whether or not people think they're powerless. And that's what they think today, is that they have no power. You can help fix that, and you can make sure that other counties are protected from that in the future. Last question, as I was sitting, somebody asked if we've taken steps to try to place this in front of the voters. The majority of my colleagues in the legislature voted to place this in front of the voters in November. The county executive vetoed it after the deadline for us to put it on the ballot. I've brought with me today a letter in support from the majority of the legislature, signed by 5 members out of 9, and some of them couldn't sign because we just didn't get around to it. This was all put together at the last minute. The bottom line is there is an outcry from our community to help us fix this. And are we trying to help ourselves? Absolutely. Is there resistance to fixing it? Yes. Why? I can't say. Representative Barnes, who I happen to note represents the Raytown area, she has constituents who appealed their 2023 assessment, whose appeals still haven't been heard. And the protections that are in Missouri statute really protect people from increases from the prior assessment. Now imagine this, somebody that's one of your constituents gets a 14.9% increase, and that's lawful without an inspection, without comps. It's just a computer estimate that the value of that property has gone up, but it's based on a 23 assessment that they're still appealing while their savings is eroded, while they're trying to hold on. So that's the testimony that I wanted to give. I'm happy to answer questions.
Representative McGaugh,
To inquire.
proceed.
Thank you, sir. I appreciate you being able to describe the taxing process the way you just did. I think this committee and the people listening and watching in the audience needs to know how diverse and how important it is to have these type of things in front of them so that everyone throughout the state follows the same process. I live in Carroll County, and therefore I get Kansas City news. So, of course, I've watched the whole process throughout the news, and my friends who live in Jackson County as well. What I heard, though, today was that you have a much, much larger problem than just your assessor needing to be elected, because I'm very concerned about the BOE process, that you have cases from 23 that have not been heard. What is that process? What's the problem?
Yeah. Well, when you say what's the problem, my hope would be that I could explain the human motivation behind the kind of holding on to a clearly defective process. But pragmatically speaking, we have 300,000 parcels in Jackson County. Somewhere in the order of 75% of those went up by 15% or more, requiring a physical inspection. Most of you may know, some of you may not, that there's a trial going on right now. I sat in the trial all last week, where the State Tax Commission issued a lawful order that said you must roll back all increased assessments that went above 15% increase back to their 2022 level plus 15%. The county refuted that, and that's where we're in trial right now. Some of the challenges with the BOE process had to do with sheer volume. When we increased 75% of people's properties by over 15%, not only was it mathematically impossible given the labor that we applied to actually have conducted those inspections, but we also put ourselves in a position where tens of thousands, actually 54,000 people appealed. And I will share with you that I know for a fact there were people who wanted to appeal and couldn't navigate the process. This was well covered in the news as well as my personal observations. We had thousands of people who would try to place an appeal via phone call because they weren't comfortable with computers. And the company that we hired to staff that, in other ridiculous ways, they were clearly deficient. And one example of that is that they had an East Coast call center. And so they shut down at 5 o'clock Eastern time. But they advertised that you could call until 5 o'clock, which of course people in Kansas City assume means Central time. So there were lots of people who were even denied the opportunity to appeal. And then when you look at the number of appeals, we have a Board of Equalization that consists of 3 members plus some local community members. And they can get through about 100 appeals a day if there's absolutely no discussion. As a practical matter, what they really get through is about 40 a day, and they had 54,000 appeals to hear. Processes were put in place to help to alleviate that through an informal kind of negotiation process where somebody could come in and meet with the assessor. That process often left taxpayers walking away with what they call a stipulation, a signed agreement that they said, okay, I can accept that my property is worth this. But then in numerous cases afterwards, hundreds of cases, I heard from those taxpayers that they felt intimidated by the assessment staff. That assessment staff included the software vendor who generated the estimate of that property value and were told, justify them, don't negotiate down. So they weren't trying to get to the right value. They were trying to justify that their software had done its job right. People walked away and signed those stipulations in some cases because they were threatened with the idea that if you go to the BOE, your property value is likely to increase. This is somebody who claims expertise that says, I'm looking at my computer screen and its fancy numbers, and I'm telling you your property value is likely to increase if you continue to pursue your appeal. Those kind of coercive actions, in some cases, we're able to reverse, but the number of times you don't hear from your constituents, I think you'd all agree, far outweighs the number of times that you do. So if you hear about something 10 times, chances are that means at least, several multiples of that have experienced that same problem. So we have some tremendous challenges, and we've worked on reforming those things as well. In our case, there's a political division, bipartisan. 5 members want to reform some of these processes so that those kinds of things can't happen. The county executive has 4 members who continue to side with him, including the other Republican. So this is not Republican versus Democrat. This is simply, seemingly, people who think that the process is fine and aren't as plugged in with their constituents, and then other people who are really plugged in with our constituents and are desperate for help. I don't think this is a silver bullet, just to be clear. I don't think this fixes all the problems. I'll head right back to work tomorrow, and I will continue to try to fix problems locally as well. But the reality is that this is a protection that should be in place for our citizens and for every citizen of the state of Missouri, because this state gives county assessors the authority to effectively take away people's properties. If you inflate somebody's value enough that they can't pay their taxes, their property is no longer going to be theirs, either through a bank foreclosure or through the actual tax sale. So, sorry, that was a long answer, but it seemed worthwhile.
The long answer, though, showed your knowledge on the subject, and I do appreciate that, and that you coming. Again, I feel like this bill and the problem that this may resolve if passed by the voters, and I truly do believe in elections being able to determine who, runs the offices. But I think you have so much of a larger problem that it needs to be addressed in some way, and it could be that you need more than just the BOE to come in, and that should be included. But if you have political on the side, then the opposite party gets in as the assessor, I don't see that going away.
So again, I don't think that the assessor's role necessarily. And by the way, I'll point out that I don't know if an elected assessor in Jackson County would be partisan or nonpartisan. I'm elected as a Republican. Our county executive is elected as a Democrat. There are provisions of our charter, for example, that if we remove our county executive, we need to appoint another Democrat. So it is it's structured as a partisan county at this point. Something I'd love to see change, but at the end of the day, for the assessor's role, what I would hope is that simply through knowing that at the end of their term, they're accountable to the voters. If their actions aren't perceived as being fair, then that helps to alleviate this. The other witness that I brought with me today is our former assessor, and he will testify as a former assessor exactly the kind of the pressure that he was subjected to. If you imagine, and we have this issue right now in Jackson County with our county attorney, the county executive can fire our county attorney. If I seek to reduce his budget, I'll be darned. There's legal reasons that I can't do that. Is that a great structure where he's subjected to the political pressure of his boss, the county executive, and then he's giving us supposedly unbiased opinions, it's a challenge, right? And in the case of elected officials like our county sheriff, what I know is that while they might have their friends who they take care of and, pat on the head when they maybe, were caught speeding, the reality is that what I'm talking about is structurally whether or not the people we're all responsible for helping govern are going to believe in the system or not. And right now, we have a shining example where an appointed assessor destroys that trust. It destroys it, and it makes people feel powerless to the point that they resort to murder. Think about that.
Okay, thank you. We're going to move on here. We've got 3 more people that have questions. Representative Voss, you had a question. Representative Woods,
Yes.
proceed.
Thank you, Mr. Chairman. Good morning, sir. Thank you for joining us. I do appreciate some of your clarifications on the local mechanisms and the attempts of the Jackson County Legislature to enact that at the local level. So I think that was one of the questions that was kind of hanging out there. And I also appreciate your explanation of the BOE process and the assessments and the appeals and how that works, because that's one thing I did not fully understand. But I wonder if do you know what the BOE's current backlog is?
Right now, we still have about 8,000 cases from 2023. That's just residential appeals. We're only really here, the assessor's responsible for commercial as well, so we're kind of talking about commercial. In the 2023 reassessment, commercial appeals that were sent to the BOE, none were heard until after they got into the following year, because there were so many residential appeals. So the idea that the backlog is just residential appeals is somewhat limited. Overall, I think we have about 10,000 outstanding appeals associated with either 23 or 24.
Okay. And how often do they meet to review those appeals?
So according to state statute, the goal is to meet only for the 3 months of June, July, and August, so that then the preponderance of appeals are known, the aggregate value of all properties is known, so then local municipalities and school districts can set their levy rates based on an accurate view of what the aggregate value of all the properties is. Our BOE met continuously 5 days a week, with some exceptions for holidays or maybe not having a quorum because of a holiday. They met 5 days a week for almost the entire year, the exception of work stoppage, if you will, because their fee structure was based upon the idea that they were going to meet for 3 months and get paid a pretty handsome sum during that time. And then they do meet, throughout the year. They'll normally, if it wasn't for this exigent set of circumstances, they would maybe have a couple meetings a month so that little straggler cases could be heard as well. But yeah, they've been meeting 5 days a week until they had their little labor stop, which was also associated with the fact that we had court cases pending, where the BOE was listed as a defendant. So, and that includes the State Tax Commission, and the Attorney General suing. And the state has tried to intervene here, just to be clear, and the county's counselor's office has gotten off on technicalities, for lack of a better way to put it.
Okay. Thank you. Sorry.
Thank you. And we got Representative Coleman. Do you have a question?
Yes, to inquire.
Please proceed.
Thank you, Mr. Chair. Mr. Smith, you and I know each other, and I just have a quick question. You've answered it, but I really want to pinpoint down to the fact, who does our assessor report directly to?
Yeah. In Jackson County, the assessor is appointed by the county executive. That's Frank White. Frank White Jr., I think specifically. You guys might know him as a former second baseman for the Royals. He's been our county executive for almost 10 years, elected twice, appointed once when previous county executive was resigned because he was up on federal charges.
And quickly, our county executive lives in a nice area, Lee Summit. Do you recall what his assessed value was?
I do, and I'll even, if it's okay, offer a more expansive answer. So the county executive's property value increased by 7%. The average increase in the county was 30%. No elected official experienced an increase of less or of more than 15%. My own home was basically flat. Was this orchestrated? I don't know. But it, again, I think calls into question why a loss of confidence in our appointed assessor might be present, is because that's the kind of authority that an elected assessor could have and could abuse. Was that abuse in this case? I don't know. My value was actually accurate. I didn't have anything to complain about. But, you know, when we talk about trust, this is another example of why people have eroded trust, is because our county executive's increase was 1/4 of the average for the county.
And his direct neighbors, do you recall what their increase was?
Yeah, most of them were considerably more. And, you know, you can think about it as a percentage increase, and you can think about it as just aggregate value of the property or gross value of the property. In both instances, it looks highly suspect, meaning that the actual value of his property seemed like it was lower than his neighbors for comparable homes.
Right. And I think that's the biggest issue, right? It goes back to your statement that the people of Jackson County have lost their trust in the system because of just the perspective and the fact that what it looks like. Whether it's true, we don't know for sure, but purely what it looks like, it doesn't look good. And so, yeah, I think it does the county and the people good to have that separation and to have that accountability to the people and not to the county executive. So I appreciate your testimony and you being here.
Thank you.
Representative Barnes,
To inquire,
proceed.
how long has Jackson County had an appointed assessor?
I believe the answer is since we were incorporated as a charter county in 1972. Mr. Johnson, who's going to follow me, might know for sure as a previous assessor himself.
And the final one I'm going to call on is Representative Waller.
You answered one of my questions, but I want to clarify. So the county executive is the one that appoints the assessor.
Correct.
What are the requirements for them? Is there any, like, real estate background, or is there anything, or is it just a pure appointment, period?
Yeah. It truly is a pure appointment, and I will share that in the case of our current assessor, she was a former state representative. She's very much politically active, but she's also an appraiser herself. Being somebody that comes from a corporate background where I implemented large, complex systems and processes, I will say that in my view, knowing how to individually appraise a property is not the type of expertise that our assessor would necessarily need. What our assessor would need is more at an executive level, an understanding of good processes, good systems, good checks and balances, good segregations of duties. When we have, for example, the same person who makes an estimate of a home's value and then is there to deal with the taxpayer and try to justify it, much less when it's an independent company. Those kinds of flaws wouldn't necessarily be picked up by somebody that's a real estate expert or somebody who's an appraisal expert. They might be the best appraiser in all of Missouri at accurately appraising what one home is worth. That's very different than managing a staff of 120, contracts in the tens of millions, and these large volumes and complex processes where you have to really say, what should a process look like so that the person who made the original guess is not the same person that's trying to decide what the actual value is in a settlement negotiation.
Okay, so to me, it's a little contradictory, a little bit. Then you're saying let's say you get this approved, the legislature approves this, and your assessor is elected.
Yep.
Well, the first election is going to be an open seat, and it's going to have multiple people running for it. Who's to say that person that gets elected is not a former state rep, a former baseball player that can go in there and be worse than the person that was appointed? Now, I'm looking at both sides of this. I'm looking at both sides. Who's to say? Because we all know in politics, it isn't always about who's the most qualified. It could be who has the most money. It could be a businessman that says, I want to be the assessor because I know Representative Coleman, they could do that. The other thing is you made a comment, and I think you answered the question. if the county executive, he has the power of the BOE appointments, correct? If a
Correct.
BOE person says, I'm done, he appoints another one, right? So he has full power over the assessor and the BOE, which is too much power, I think. When you guys tried to put it on the ballot and you said it was not approved, you was meaning it was not veto approved.
It was
meaning that
vetoed by
you
the
had
county
enough, you had votes to get it passed, you just didn't have enough votes to override the veto. What is your, like, how many do you have and how many did you need to get?
Yeah, we have 9 members of the legislature.
Okay.
5 of us approved to put it on the ballot,
And you needed 6?
and we need 6 to override a veto.
Okay, and you did not have that, and that's why I did, okay.
At that point, we did not. And going back to your question, I said that I didn't think this is a silver bullet, right? By no means does this fix Jackson County or any county's problems. What I think this fundamentally does is offers the opportunity to place some perception of control in the hands of the voters.
Well, yeah, because right now, the county executive has the power. I mean, it's not really the assessor. The county executive pretty much has all the power because he puts the assessor in position and he puts the people on the BOE, and if somebody leaves the BOE, he puts another person on there. And I'm not going to say they're always his friends, but they're going to be people that he knows and wants to have on the board. I was a county executive for 8 years. I know how it works, and I'm glad I didn't have to worry about to some degree, I'm glad that the assessor was elected, but, I guess everybody's different, so thank you for your being here.
You bet. And like I said, just to respond, I would not say by any stretch this is a silver bullet. This is, I don't want to call it a feel-good measure because it's more than that, but it is a measure that allows voters to feel like they have a say at a point in time and can fix the problem. That's very different than having voters feeling helpless, and that's what we have today in some cases. So.
Okay, thank you. I think Representative Bosley maybe wanted to be recognized one more time.
Just one question for the witness, Mr. Chair. You kept saying that having an elected assessor would possibly bring back trust to the people and to the office. How do you think that would work?
Yeah, if I said trust, that may or may not be the case, right? That they would trust the person. But the reality is, what I perceive is that the voters will perceive, and taxpayers, that they have some modicum of control over who this person is. Right now, a county executive has many things that people might decide who they want their county executive to be based upon. Lots of different policy things. And this might be only a fraction of the things they have to think about. By having somebody who's being elected based solely on this area, I think that it lets voters make a decision. Who do I think will competently do this job that's so important to us and has so much authority?
Thank you. Thank you, Mr. Chair.
Thank you, gentlemen. Thank you for your testimony.
Did I leave